Hi, my name is Samantha Neely, and today I'm going to be presenting my critical assignment topic on legal issues in kinesiology. So, the facility that I chose was an indoor volleyball gymnasium or even a beach volleyball outdoor stadium, just any facility that involves playing volleyball. The reason I chose this facility is because I am a volleyball coach and I also teach volleyball at Mount San Antonio College, the physical education classes. So I'm dealing with these facilities every single day. The top picture is an actual picture of Mount SAC's indoor gym, and the bottom picture is a picture of Mount SAC's outdoor sand facility. I had the opportunity to compete for Mount SAC on the beach team, so that's an actual action shot of me playing. But obviously, these facilities are relevant to me because I work in them every single day. Going on to risk management topics within this facility, I mainly focused on the indoor gym just because beach volleyball is a relatively new sport in the college realm, so there's not very many sand facilities, but I did choose to include a few cases involving sand facilities. The first case that I chose is Govell versus the Board of Education, and this is a case involving an injury during a physical education course. So basically, a student was injured, they broke their leg while participating in a PE class that happened in the gym of this school, and the um, the outcome of the case was that the PE teacher was negligent in the fact that they were assigning the students dangerous activities. In this case, the student was performing a somersault without any sort of padding or anything under them, and it resulted in a broken leg. So the PE teacher was found to be negligent, and therefore the school was found liable for the injury. This was due to the fact that PE teachers have a duty to take reasonable care of their students and any foreseeable risks that they see. They have a duty to prevent that. And also, the Board of Education was held responsible for not establishing rules to control what these teachers are able and not able to do. So, going forward, as mentioned in the case, this could have been avoided if the school district had established rules for control of teachers so that those guidelines are better set out and those injuries can be prevented. The second case is Yeater versus the Board of Education, and this is another case where negligence was found upon the coaches that were responsible for overseeing players during a volleyball practice. So there was an injury that occurred while a player was carrying a volleyball pole. The bolts malfunctioned, and the pole fell on the student's foot, which injured several of their toes. The coaches and school were found liable because these poles had not been inspected for months, and this was a foreseeable risk that they could have prevented because it was physically evident that the poles screws were not functioning properly. A way to prevent this from happening is to inspect the equipment and make sure that there is somebody responsible for inspecting that equipment, whether that be the coaches themselves, or I know at my college we have an equipment manager that is responsible for taking care of all the equipment and making sure that they're up to date. So whoever that may be, just making sure there is somebody held accountable for inspecting those things. And then the third case is probably the most interesting for me because it involves a community college that is actually in our district that we play every year for beach volleyball. Mount San Antonio College plays Grossmont College, and this case involved a player who was visiting Grossmont College's sand facility in order to play a match against Grossmont College. And while she was competing in the sand, she dove onto a rock and injured her knee. Now, the college was found liable because of their negligence to provide reasonable, a safe and reasonable environment for players to play in, which I found to be interesting because this case was from a couple years ago, and I actually just competed in their sand court this last beach season, and I found that it was a terrible facility before even knowing about this case. The sand was very, very shallow. I actually scraped up my knees because I found hard concrete under the sand, so I found it interesting that they didn't really make any fixes to that after going through this court case and losing. But but yeah, so a way to prevent this is to make sure that somebody is held responsible once again for raking the sand every day. I know in our facility we rake the sand every day before practice, make sure that there are no rocks in the sand, no bees or any other sort of weird thing that could hurt somebody while they're stepping in the sand. And then additionally, just making sure the sand is deep enough. A lot of these college facilities are man-made facilities because colleges are not on the beach. So that means that there's a lot of the time concrete underneath that sand. Just making sure that there's enough sand covering that concrete so that it never gets down physically to the concrete. Next, employment laws. So I found this section to be interesting as well because I have always heard about discrimination, but actually seeing it in these cases, it's quite unbelievable that it still exists today, but I'm glad that I'm learning about it so that I can to maybe be an advocate for change going forward. So the first court case is EEOC versus Madison Community Unit School District. And this is a classic unequal pay case. So basically, it was found that the female track, tennis, basketball, and volleyball coaches were being paid significantly less than their male counterparts that were coaching the exact same sports and had the exact same responsibilities as coaches. And this was interesting for me to think about as a female coach, what that looks like to have equality in the coaching realm. So a couple fixes that I could think of is, first of all, making sure the salaries are made public so that all coaches are aware of what everyone else is making. Now, if these things are posted, then it is very difficult to have that pay gap evident when everyone is aware of that pay gap that is happening. If we have the salaries kind of hidden, then it makes things a little sketchy and we're not really sure if there is a gap or if there's equality going on. And the second thing that I found very interesting is I found a study that talked about negotiating in the business realm and how females and males kind of fare different in that, and how that kind of leads to unequal pay. So it was found that females are more likely to just accept the first offer that they're made for their pay versus males who are going to be more likely to negotiate their wages a little bit. So even if somebody was offered $30,000 and the female coach accepted that as their wage and the male coach negotiated up to $35,000. Now there's already a $5,000 pay gap, and then as the years progress and maybe the salary will increase by 2% each year, now that gap is getting substantially and exponentially bigger and bigger each year. So either taking away negotiations and just having a set kind of grid on how coaches are paid, or making sure that females are empowered and are capable of negotiating and know that that is totally okay. I took a negotiations class in undergrad and I thought it was so helpful, and that has actually helped me negotiate up a little more instead of just taking the bare minimum of what people offer me. Knowing females kind of knowing their worth in the coaching realm. Second is Kenny versus University of Delaware. This is a volleyball coach that was wrongfully terminated based on their sexual orientation. So they were accused by a player that the player was being unfairly treated by the coach. Now the coach was immediately terminated, but this termination occurred and this complaint occurred immediately after the coach had married the assistant coach. So it was a homosexual marriage, and this termination happened immediately after that marriage. And it was shown that the sexual orientation of the coach was involved in the decision to terminate the coach. So obviously that is not legal under Title IX. So something that we can do to fix this is just being aware of the reasons for termination. So this coach it was stated that this coach had a fantastic track record as far as scores and wins go, and then they also had fantastic reviews. This was one of the first times that any player had complained about this coach, and they were basically terminated immediately because of that. So not only being aware of why we're terminating the coach, but also maybe taking other players' interviews and testimonies into account to see if this coach is really wrongfully treating players, or if it's maybe motivated by a separate reason. The third case that I came across was Sonnichsen versus Baylor University, and this coach was terminated for being accused of fraud and violating their contract. Now, the fraud accusations were found to be false, but the contract violation was actually legitimate. Now, the coach brought this issue to court with the cause of action that they were being wrongfully accused of fraud and contract violation. Since the contract violation was found to be legitimate, then the university was not found violating any sort of employment discrimination. But some way to prevent this case even coming about is that it was mentioned in the case that all employees, or all coaches, except for the basketball and the football coach, had oral contracts. So there was no contract in writing, it was just oral contracts, which causes for some miscommunications in how that plays out, obviously. So one fix to this is just to make sure that everything is in writing so that both parties involved are able to understand what they are responsible for and what the terms and conditions of the job is. All right, next up is application and faith integration. So as far as relevance to a professional career, like I mentioned before, I'm a collegiate assistant volleyball coach, as well as working with youth volleyball and teaching physical education courses at the college. So this is very relevant to my job. The one thing that stuck out to me over and over again after reading dozens of court cases was foreseeable risk. So something that I'm going to take with me is just being very aware of my surroundings and of the facilities that I'm working in. So anytime something is foreseeable, I need to do something in order to prevent that injury from happening or from something bad happening, because I could have prevented it. So I've been very aware, even within these last 8 weeks, being a coach in our gym, looking at our gym and kind of realizing, hey, that bench sitting right there has really sharp corners and it's kind of near the court, that might be risky. Or hey, that huge fan in the corner looks really old and probably not the safest. Maybe we'll move that a little bit farther away from the court or move some sort of padding in front of it so that it is no longer a foreseeable risk. So just seeing those things, I'm kind of more aware of my surroundings, which is helpful. And then secondly, just considering all the employment laws and the employment cases that I reviewed, just being aware of the hiring process, both as somebody who maybe will someday be an athletic administrator, and in a position to hire people, or just while I'm being hired for another coaching job. Just making sure that I'm being treated fairly and I'm treating other people fairly, and just knowing what is right in those circumstances. As far as where faith comes into play, I think it's always really difficult to decipher between God's laws and man's laws. Obviously, God's laws are supreme to all others, but in this world we live in, obviously we are living under a government and under certain laws that are created by man. So how do we deal with that in deciding what is right? And when we are in a position to make a judgment for justice, looking at precedent and seeing how other cases were decided. Now, sometimes when you look at precedent, you're like, do I necessarily agree with that? I know I have come across instances where I feel like that, but I think it's important to remember that God sets precedents. So regardless of what a specific court case necessarily said, I think it's always important to look back to the Word and see what God has to say about it, and see how those laws align with that. I was reading in Proverbs 27:23. It says, know the state of your flocks and put your heart into caring for your herds. So this kind of has to do with being a manager and how to treat your employees. So just always knowing that your employees, you are working for your employees. Your employees aren't just working for you, and treating them as such. Knowing how they're feeling all the time, knowing what they're doing, holding them accountable, upholding those laws, because ultimately laws are put into place for good. That's how it should be, at least. So I think it's important to follow those laws. And if I do see something that doesn't necessarily match up with God's law or the way that I believe in, to maybe be involved in that and maybe throw some questions out there like, hey, is this really what we want in this law? But these laws are set into place for a reason, so I think it's important to follow it until we can make a change for the better if that's what is needed. The next one is Proverbs 28:4-5. And this says, to reject the law is to praise the wicked, to obey the law is to fight them. Evil people don't understand justice, but those who follow the Lord understand completely. So once again, don't reject the law. Always look to God's law, and always look to be the good for the world, regardless of if that law is set in place now or if that's a law that you can maybe influence in the future. And then looking at Romans, I was kind of just thinking about the question of what happens if the laws don't match up. This kind of just goes back to the idea that these laws are set in place for a reason, and law enforcers have a responsibility to be good. Now, this isn't always the case, and that is the hard part, because not everyone in the world is a Christian, and not everyone understands the importance of good and laws trying to prevent evil. So looking at Romans 13:10 and Romans 13:4, this just kind of discusses, Romans 13:10 says, love does no wrong to others, so love fulfills the requirements of God's law. And then Romans 13:4 says, the authorities are God's servants sent for your good. That's just the beginning of it. And I think it's just to remember that people, if you are in a position to enforce a law, I think it's super important to enforce it to the highest of your ability and to make sure that you're doing a great job doing it, because when people become corrupt, then that is going against the whole point of these laws in the first place. So overall, I think that although I wasn't super excited to take a law class, I thought the word law kind of sounded icky. After taking this class, I found it to be very interesting and super relevant to my life and affecting other people's lives in a positive way. Thank you for listening to my presentation.